Hello and welcome. There's been a landmark ruling in the case of 4 British Christians who say they suffered workplace discrimination because of their faith, because their beliefs either affected the way they dressed or the way they conducted their job. Only one plaintiff won, Nadia Awida, who wore a cross around her neck to work at British Airways. Today's ruling from the European Court of Human Rights revives the wider debate about where that balance should lie between expressing your religion and the rights of others where you work. Here's the BBC's religious affairs correspondent, Robert Piggott.
This was the day an airline check-in clerk took her fight to display a cross at work to Europe's highest court and won. Nadia Awida's victory confirms that wearing a cross is a legitimate way of expressing Christian beliefs. Ms. Awida's case was special. The court said her cross was too discreet to spoil British Airways' corporate image. She said the judgment sent a signal to employers.
It means that Christians can move around more freely in their workplace without recrimination or discrimination.
But 3 other Christians lost their cases. Shirley Chaplin, a nurse from Exeter, was told by her employers that the cross she wore was unhygienic. Lillian Liddell, a council worker, lost her job when she refused to register civil partnerships. And Gary McFarlane was sacked when he refused to counsel gay couples about their sexual relationships.
The implications really, I think, is that a lot of Christians will remain hidden, will remain unable to exercise I would say, the minimum expressions of their faiths because of the intimidation effect.
Legal experts say the judgment gives wide discretion to employers to override the religious concerns of staff.
If I have a concern that it's going to affect health and safety, if I have a concern that it's going to affect my ability to provide a service in a non-discriminatory fashion, then I can limit the right of an employee to manifest their religious belief in that way.
Today's judgment sets a legal seal on years in which traditionalist Christians have gone to British courts and tried unsuccessfully to defend their values against secular ones. It confirms that although people are fully entitled to hold religious beliefs, they won't be allowed to infringe the rights of other people in the workplace. Secularists claim the European Court's judgment will stop religious views being given special privileges.
We're delighted that they haven't resulted in the creation of a hierarchy of religious rights with religion at the top and gay people potentially very badly affected.
For decades, the influence of Christian teaching on British culture and law has been waning. Today, the European Court of Human Rights left a milestone on the road to a secular society. Robert Piggott, BBC News.
Well, with me from the British Humanist Association is Andrew Copson, and Andrew Marsh joins me from Christian Concern. Andrew Copson first, your reaction: 3 out of 4 of these cases, they were told that there wasn't a case. They couldn't wear the cross or express their concerns in the way that they'd wanted to.
That's right. I think the court asked the right question. They asked who would be harmed, would anyone be harmed, would another person be harmed by the manifestation of this person's religious belief? They asked that question and they answered it correctly. In the 3 cases of the counsellor, the nurse and the other one, sorry, I've temporarily forgotten. In 3 of the cases, they said yes, someone will be harmed, and because of that, because a gay couple won't be able to get counselling or a civil partnership won't be able to be given by the registrar, that was the 3rd one, those people would be harmed, and so it's legitimate for the employer to limit their religious freedom. So from your point of view, it's common sense. Andrew Marsh, how do you see this? Obviously, Nadia won her case with British Airways, but it didn't go your way for the other cases?
Well, I think behind the immediate headline, actually there's a major step forward here for Christian freedoms and for securing and aligning those Christian freedoms, and indeed freedom of thought, conscience and religion for all manner of people in society. Clearly in the case of Nadia Awida, because the case was won, but in all the cases, actually some important points were made, countering the position that had been adopted by the UK courts and indeed by our own UK government. Importantly, that manifestation of religious belief and of Christian identity does extend to something like wearing a cross and therefore is in principle protected. And I think crucially that For example, the conviction, the belief that marriage is between one man and one woman is an aspect of and flows from Christian identity and is therefore protected. That may sound trivial to mention those things, but the government's case had actually suggested that
forward
it is
from the point of view
because
of Christian concern.
the government had argued in court that in fact the cross was not a recognisable Christian symbol, and therefore
it seems to me that there are two areas here, aren't there? There's the wearing of the cross, and there has been a legal victory in that case for the wearing of a cross to the workplace. But there's also the fact of your religious beliefs and the way you conduct your job. And when we look at the other cases, for example, the registrar who said, I feel uncomfortable conducting gay marriages or gay civil partnerships, if you choose between your religion and your job, this ruling seems to say, well, you know, you have to leave the job.
In many circumstances, yes, and I think that's right. I think that the victory...
That's the right thing? I think that you should make that choice.
I think cases are so dependent on their circumstances. I think that's really important. Employment cases are very, very dependent on the circumstances.
But you
and the devil is really in the details.
Precedent?
In the 3 cases where we saw that decision be made today, I think it was a good precedent. And I think probably on balance, the ruling on the wearing of the cross at BA was fair enough as well. I think it was really a relatively trivial victory, actually, because after all, BA had already changed their uniform code and allowed the cross to be worn. But I think the fundamental principle that a person's religious beliefs shouldn't allow them to infringe another person's basic rights and freedoms, the right to have a civil partnership, the right to be treated equally when you're accessing a service like marriage counselling. I think that's what's important. I think that line is now very clear.
That is key, Andrew Marsh, isn't it? Especially as we talk a lot about gay marriage in the Church of England and in wider British society.
Absolutely, and I think that I would in one sense, take up the same point that Andrew has raised, where it impacts on the rights of others, because the truth is that in each of these situations, the individual's Christian identity could have been reasonably accommodated without any risk of detriment, any risk of someone being denied a service to which they're entitled.
So it would have been all right for you, for example, for a registrar to say, I am willing to join in civil partnership or holy matrimony everybody who happens to be heterosexual.
I think the point is that, and I come back to the question that Andrew raised at the beginning, of the victim. Where is the actual victim? No, not a conceptual victim, but an actual victim, someone who is entitled to the service who couldn't get it. And the truth is that in these situations...
So you're saying no harm done by the expression of religious belief?
Well, I think that... I mean, many legal cases depend on theoretical victims, right? So, I mean, I don't think it's enough to say, oh, Lillian Nadeley never actually walked out of a civil partnership and refused to do one. Gary McFarlane never actually stood up and said, I can't... Yeah, the therapist, the marriage counsellor, never stood up and said, I can't, I can't talk to you about this because you're a gay couple. It doesn't matter. If you're given a job to do and your own beliefs mean that you can't do parts of that job, I think it is right for an employer as a general principle to be able to say, actually, you can't do that job. You can't do that job.
You can argue different precedents from this, which is what's happening with 4 cases, and it seems to be, to me, that there are bound to be more cases. This doesn't solve anything,
and I
really.
don't think there's much comfort here for the...
I think that's absolutely right. I mean, as you know, these cases, the judgment is not final. There's opportunity to take it to the Grand Chamber over the next 3 months, and that will be looked at because some of these points of principle are so important. And I think we have precedent in other areas. I mean, if we take the contentious issue of abortion, we have a situation here in the UK where no one who is entitled to that service is denied it, and yet we can make provision for the conscience of many doctors.
And there we go into a completely different debate. And actually, gentlemen, I am going to have to leave it there. That could be a whole other programme, couldn't it? Andrew Copson, Andrew Marsh, thank you for joining me to talk this through, and clearly it is a very wide-ranging debate.